A few weeks ago, before the United States Supreme Court decided the Rahimi case involving 18 U.S.C. 922 G8, Brett Kavanaugh gave an interview in which he talked about how he is a longtime fan of Taylor Swift, mostly because of his two teenage daughters. He said he was a Swiftie before many people became Swifties. Why is this important? Well, it seems to me, by my review of the concurrence by Brett Kavanaugh in Rahimi, he may have dropped some Easter eggs a la Taylor Swift, meaning clues about what's coming next. Did Brett Kavanaugh drop some Easter eggs or clues about upcoming Second Amendment cases? Let me know after I give you the evidence. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10-7 Attacks That Teach Americans about the right to bear arms. A lot of really important gun-related history throughout the world in that new book, Israel Disarmed. Check it out on Amazon. All right, folks, so this video is about a little bit of speculation, but I think it's well-founded about where the Supreme Court's going to be going. What's interesting is that Justice Brett Kavanaugh has previously indicated where the court is going to go, and he's turned out to be correct. We'll get to that in 1 second. But I want to start off with an interview that Brett Kavanaugh gave about a month ago, where he was asked a series of questions about his life, about his law, jurisprudence, and the like. In that interview, he disclosed, because as a prompting by the interviewer, that he was a fan of Taylor Swift and had been a fan of Taylor Swift for like a decade, mostly because his two young daughters, now teenagers in high school, were big Taylor Swift fans, so they would drag him along to Taylor Swift concerts, which he willingly went to with his two daughters. So he discussed how he was a fan of Taylor Swift. Now, the reason why this is important for this video is that Taylor Swift has made something very famous in the world of pop culture. That is the use of what are known metaphorically as Easter eggs. Easter eggs. Now, what is an Easter egg? Now, we all know what an Easter egg is from the spring holiday of Easter. They're little eggs that are painted and decorated to celebrate the coming of spring, and of course, the resurrection of Jesus Christ if you're a Christian, and so on and so on. But Easter eggs also have another meaning, a metaphorical meaning, in the context of pop culture involving Taylor Swift. Specifically, Taylor Swift is known for dropping what are known as Easter eggs in her songs or her lyrics or her music videos. And these Easter eggs are hidden in plain sight, if you will, for her fans to try to learn or check off these clues and figure out what the song is about or who the song's about and things like this. So she is known for putting Easter eggs in these songs, in her lyrics, in her videos, for her fans to uncover some hidden meaning that's unavailable if you don't discover these Easter eggs. Also, Easter eggs are sometimes found in video games where there's like secret clues that are hidden and get revealed. Now, the reason why I'm bringing this up in the context of the U.S. Supreme Court decision in Rahimi and Brett Kavanaugh's fandom of Taylor Swift is because I think, looking at the Supreme Court opinion and Brett Kavanaugh's concurrence, he may have dropped a very interesting Easter egg or clue about a case the Supreme Court is going to take very soon. And that is a case involving whether or not quote-unquote assault weapon bans can be banned, i.e. semi-automatic rifles and AR-15s. Can they be banned? Which in the situation today would be one or more of those Illinois cases that are up on cert with petitions for cert right now out of the decision by Judge Easterbrook and Judge Woods, two terrible anti-gun judges in Chicago, whether or not the court will grant cert to those cases, which they're still pending. Now, it would be a little unusual if cert is granted in those cases because they're on what's known as an interlocutory basis, which we've discussed before, which is mean there's no final judgment in the cases. Those cases are still being processed. So it'd be a little unusual for the Supreme Court to grant cert in the Illinois cases because they're interlocutory right now in terms of their procedural posture, but it would not be impossible. So let me give you what I think may have been the ultimate Easter egg by Brett Kavanaugh of where he thinks the Supreme Court needs to go, specifically to deal with these clearly unconstitutional bans on ordinary semi-automatic rifles. So to begin with, let's turn to the majority opinion which Brett Kavanaugh agreed with and signed off on. Does the Supreme Court's opinion in the majority of Rahimi speak to the assault weapon issue? The answer is yes, it does, and it does so in a way that's very favorable to the Second Amendment. Let's look at what the court writes in Rahimi about assault weapon bans and what is protected under the Second Amendment. As we explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than those regulations identical to ones that could be found in 1791. Listen carefully. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. Brett Kavanaugh signed off on that language, as did 8 Supreme Court justices. Okay? Very good language for us and the assault weapon. But does Brett Kavanaugh do more than that? Yes, he does. Let's take a look at his concurrence, where he writes an extensive concurrence about originalism. Again, what does Brett Kavanaugh say that's quite interesting in his concurrence in Rahimi? Well, he specifically talks about an assault weapon ban case, one he was quite familiar with, specifically his decision in what's known as Heller 2, when Brett Kavanaugh sat on the United States Court of Appeals for the District of Columbia. He dissented in a case, and he found in his dissent that AR-15s are clearly protected arms and cannot be banned under the Heller in common use test. Let's see what Brett Kavanaugh has to say in the context of his discussion of Heller 2 in the Rahimi case in his concurrence. As the court's decision today notes, Second Amendment jurisprudence is still in the relatively early innings, unlike the First, Fourth, and Sixth Amendments, for example. That is because the court did not have occasion to recognize the Second Amendment's individual right until recently. See generally Heller versus District of Columbia, Brett Kavanaugh dissenting in 2011. Interesting cite. Very interesting cite. Deciding constitutional cases in a still developing area of this court's jurisprudence can sometimes be difficult, but that is not a permission slip for a judge to let constitutional analysis morph into policy preferences under the guise of a balancing test that churns out the judge's own policy beliefs. This is very important there for 2 reasons. One is he's, of course, reminding everyone that interest balancing is a no-can-do, that this is all about the text of the Second Amendment and the history associated with it. That's all that matters. But the reason why I think it's quite fascinating is that he's talking about how the Supreme Court in Rahimi is recognizing that they got a lot more work to do in building up Second Amendment jurisprudence. And of all the cases he could cite to, he cites to his dissent in 2011 when he was a Court of Appeals judge before he was on the Supreme Court in the Heller 2 case. And what did that case involve? It was the District of Columbia had banned AR-15s and semi-automatic rifles, and he in his dissent said that that law was unconstitutional because it violated the Second Amendment. So of all the cases that have been decided from 2008 through today involving the Second Amendment, including the Supreme Court's Heller decision, the McDonald decision, the Caetano decision, and so on, Justice Kavanaugh refers to his dissent in an assault weapon ban case, one in which he found that law to be unconstitutional. A very interesting choice of what to cite to in the context of basically saying we need to be taking more cases to clarify Second Amendment law because it's so far behind all the other aspects of the Bill of Rights, like the First Amendment, the Fourth Amendment, and the Sixth Amendments. Now, is there any other time where Justice Brett Kavanaugh predicted and encouraged the court to go in a particular direction? And it turned out that what he said historically proved to be totally accurate as to the actual direction. The answer is yes, that did indeed occur. We just have to turn our attention back to the year of our Lord, 2020. You may remember that the New York Rifle and Pistol Association case was actually before it became Bruin. There was another case where the New York Rifle and Pistol Association sued the city of New York. That was called NYSRPA versus City of New York. It was decided in 2020. Now, you may remember this case. This involved a rule by the city of New York that restricted the ability of gun owners with carry permits or any kind of gun permit to take their gun outside of New York City to practice at a gun range in New Jersey or Long Island, whatever it is. And what happened was when the Supreme Court granted cert in 2019 in this case, the state of New York and the city of New York were terrified of another pro-Second Amendment ruling, so they raced out and amended the law and effectively mooted the case. It mooted the case. And thus, the next case became the Bruin decision and not this one. What's quite interesting, though, is there was a concurrence by Brett Kavanaugh. Justice Kavanaugh wrote that although he agreed with the per curiam court's opinion that the resolution of the procedural issues by New York State and New York City had mooted out the case, so they could not decide it under the Article 3 case and controversy standard, he then went on to write the following. And again, this signaled the future. Let's see specifically what he writes in 2020. I also agree with Justice Alito's general analysis of Heller and McDonald. He cites to a series of cases, including, again, Heller versus D.C., the Court of Appeals for the District of Columbia, 2011, then Judge Kavanaugh dissenting. See? Hint, hint, hint. And I share Justice Alito's concern that some federal and state courts may not be properly applying Heller and McDonald. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court. 2020. Justice Kavanaugh wrote that. Well, guess what happened? After that, we know what happened. In June of 2022, the U.S. Supreme Court took NYSRPA versus Bruin and decided, in a huge case in favor of the Second Amendment, that the May issue permitting regimes were unconstitutional under the Second Amendment. The point being that Brett Kavanaugh flagged in 2020 in the first NYSRPA versus New York City case that we need to take more cases. He cites again to his dissent in Heller too, and he basically says he thinks the lower courts are screwing up. We got to do more work. 2 years later, we have the Bruin decision, which is a huge win for the Second Amendment. Now today, in the Rahimi case, which we've talked about is not a catastrophic loss for the Second Amendment. Don't kid yourself. It's not. We'll get into that in more detail later. But don't let the skies fall and Second Amendment people tell you it's the end of the world. It's not, okay? It's going to be fine. You'll see. But anyway, with that said, here you have the concurrence by Justice Kavanaugh in Rahimi, again, just as he did in 2020, flagging that the court needs to take more cases. And what is pending right now before the U.S. Supreme Court? There's a series of Second Amendment-related cases that are up on petitions for cert, and including several dealing with the exact same issue that Judge Brett Kavanaugh decided in the dissent in 2011 as a member of the D.C. Court of Appeals to say that AR-15 and semi-automatic rifle bans are unconstitutional under the Second Amendment and the precedent of Heller from 2008. And I think that Brett Kavanaugh, in this concurrence, like he did in 2020, as a highlight, here comes Bruin, I think he may have, in June of 2024, indicated that an assault weapon ban challenge may be granted cert very soon, or some other major Second Amendment case is coming down the pike. He may have just dropped a Taylor Swift-like Easter egg or clue in his concurrence, and that would not surprise me. So we will see, but he has a track record going back to 2020 of predicting accurately where the court's going to go. Will it remain accurate? Will he remain correct? Will that actually signal where the court's going to go with more Second Amendment cases before them? I certainly hope so, but only time will tell. All right, folks, there you have it. Hope you learned something today about Taylor Swift, Easter eggs, and Brett Kavanaugh, and my predictions and speculations for the future. Don't forget to follow me on X at @4boxdesigner and subscribe and resubscribe. I appreciate the fact we're now over 150,000 subscribers, and we're going to keep trying to grow it. And check out my book on Amazon, Israel Disarmed, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.